Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. The Constitution Bench of the Supreme Court has passed an important judgment today, which would be a great relief for many people who are suffering from matrimonial issues. As you all know that even for a divorce by mutual consent, the parties have to wait 6 months after the petition is filed. This issue has created unnecessary delay in many of the cases. There are cases where parties are fighting each other for years together and at the same time living separately as well. The issue is, can the irretrievable breakdown of a marriage be a ground for dissolution of marriage? And the other issue is, can the Supreme Court, using its extraordinary jurisdiction under Article 142 of the Constitution, grant divorce when the marriage is irretrievably broken down? Initially, the issue before the Constitution Bench was whether this mandatory and statutory period of 6 months should be followed strictly. While considering this issue, it has been referred to the Constitution Bench, and the Constitution Bench took up the collateral issue, that is whether the divorce can be granted if the marriage is irretrievably broken down, and can the court invoke its special powers under Article 142 of the Constitution of India. The position till now was that the court could not as such grant divorce when it would find out that the marriage was irretrievably broken down. Now, to understand the status, the basic issue is to find out that the marriage is broken forever. Sometimes the husband and the wife, that is one of the parties, may contend that the marriage is not over as of yet. Finding a solution to this, the court has given the verdict. Before going into the verdict, I'd like to remind the viewers of one more aspect of the issue. Just last week, a division bench of the Supreme Court held that if a marriage is irretrievably broken down, that should be treated as cruelty. As per the judgment, the bitterness in the relationship and prolonged separation and absence of cohabitation is cruelty, and cruelty itself is a ground for divorce. So the court found that when the marriage is done forever and parties are living separately in an acrimonious relationship, that in itself is considered as cruelty. In 2017, a two-judge bench of the court in Amardeep Singh versus Harveen Kaur held that the provision of waiting for 6 months under the Hindu Marriage Act is not mandatory and can be waived by the family court in exceptional circumstances. In addition to this, there were some matrimonial appeals and transfer petitions in the Supreme Court also, in which the apex court invoked the special powers under Article 142 to dispense with the waiting period. The Constitutional Bench also referred to one more case, that is Amit Kumar versus Suman Baniwal, in which the two-judge bench had held that the court should also ascertain whether the parties have freely, without any coercion or pressure, made the settlement which took care of the alimony, maintenance and the custody of children, etc. Analyzing all these factors, the Constitution Bench has returned two important verdicts. One, that the court can invoke its special powers under Article 142 of the Constitution of India to grant divorce on the ground of irretrievable breakdown of marriage, which is not yet a statutorily recognized ground, and also to waive the waiting period of 6 to 8 months prescribed for seeking divorce through mutual consent as per Section 13B of the Hindu Marriage Act 1955. The bench also said that mutual settlement between the parties to a marriage should be highly encouraged. Justice Sanjeev Khanna in the judgment said, and I quote, "The courts must not encourage matrimonial litigation, as prolongation of such litigation is detrimental to both the parties who lose their young age in chasing multiple litigations. Thus, adopting a hyper-technical view can be counterproductive, as pendency itself causes pain, suffering, harassment, and consequently, it is the duty of the court to ensure that matrimonial matters are amicably resolved, thereby bringing the agony, affliction, and torment to an end." It was also held in relation to another issue that the Supreme Court can invoke powers under Article 142 of the Constitution to dissolve marriage on the ground of irretrievable breakdown of marriage. The court also clarified that a party cannot file a writ petition under Article 32 of the Constitution of India for the dissolution of marriage on the ground of irretrievable breakdown of marriage directly from it. If you want to know more about the case, please visit our website and check out our top stories. If you like the content, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications. Thank you for watching.